Hello everyone, welcome to our podcast session on Let's Talk Law.
I'm Elaine.
I'm Eugene, and today we have Kenneth from BR Law to share with us legal questions and answers related to property. Buyer A has a son with special needs, and Buyer A lives in a condo with his wife and son. So he purchased this condo in 2019 and is co-owned by him and his wife. So the property was fully paid in cash without using their CPF. They would like to give this condo to their son. Will there be BSD or SSD incurred for both the giver and the recipient in this scenario?
When you have a child with special needs, generally once they pass the age of 21, below 21 they are under your care and control, but technically once they are above 21, the law treats them as a separate legal person, even though they still have special needs and even though they might still be very reliant on you. So generally, once they turn 21, you actually should make an application to court under the Mental Capacities Act to authorize you to be able to do things and act as a trustee on behalf of your child. So this is a very specific court application. To answer this question, okay, it depends, okay, on how old the child is. Because if the child with special needs is under 21, what is done is what we call a gift transfer by way of trust. So what it means is that you are creating a trust and transferring this property to be held in trust in favor of the child. Okay, then thereafter you all become the trustees. You all use the property for the benefit and welfare of your child with special needs. That would be the process. Okay, and since in this factual matrix the property is fully paid, okay, without using CPF. Okay, but if your child is already above 21, generally speaking, the process changes. You should actually make an application under the Mental Capacities Act. Okay, and then thereafter you transfer to the child per se under his own name. But then this creates a very tricky sort of situation, okay, because there is that degree of self-dealing. Because it will be very strange, lah. How can I do a gift in favor of my child when I'm literally signing off in a way, two times? So, but I would argue to say that if you are doing it as a gift, okay, it's still fine, lah. But if you are doing it, as a sale, then that doesn't quite work, okay. So, and I think to close off on this, there were some of my clients, what they have done, because you must remember, every time you do a transfer, be it by way of a gift or trust or otherwise, every time beneficial ownership changes, you automatically incur stamp duty. So sometimes this might not be the best course of action. And so what I've seen some of my clients do is after they have done the application under the Mental Capacities Act, then they use that authority to directly buy a new property on behalf of their child who's already above 21. So that's something that in a way saves stamp duty, because whenever you buy a property, you have already paid stamp duty once. So thereafter, when you transfer again, be it gift or otherwise, then you incur another stamp duty. So it sometimes doesn't make sense.
Right.
Yeah, and specifically also if you're making a gift to your child by way of trust, there is all this ABSD trust that's applicable. So again, you have to come up with 65%, upfront first. So, so that amount might be a bit unmanageable, lah. Even though in theory you can get the refund, of the 65% after 6 months. But once again, coming out with that sort of cash flow is a bit tricky.
Okay, so I just want to ask another question.
Yes.
Just add on to this. So in a situation whereby it's more like a grandfather and the grandson, for
Yes.
example, and maybe the grandfather will have concerns, I want to leave something for my grandson because
Correct.
of like maybe special needs. So does the relation differs, because the question we're asking now is like a father and son relation.
Correct.
Yeah, but then now there's another generation.
I think it goes back to what I call as first principles.
Mm.
And the first principles are to show that this is a very legitimate, okay, and what in law we call it bona fide transaction in good faith, okay, and that it is more importantly from IRA's viewpoint, it is not a sham, okay. So grandparents, generally speaking, if there's some relation, it is very arguable to say that I'm a grandfather, I want to create a trust over a property in favor of my grandchild. It's very, within the Asian context at least, okay, it's very acceptable. Even within the Western context, it's something that's very acknowledged as a reasonable thing to do. But it becomes trickier if there is no relationship. Okay, you have those type of goddaughter, godson sort of situation, whereby there's actually no blood relationship. We have done some of those cases, and IRAs have cleared it previously, but we will exercise a lot higher that degree of caution. It won't be a straightforward case. What we will do is that we will send that case in for adjudication, okay, and say IRAs, hey, there's actually no blood relationship. Okay, this is the self-proclaimed godson or goddaughter. Are you all going to give us the ABSD remission of the 65% on this case? So that's that extra degree of caution, okay, and that we would emphasize to the client.
Okay, so the next question we have for Kenneth is, Singapore PR buys a property and few years later passes on, but has no spouse or kids, and has willed the property to her two nieces, and the two nieces are Switzerland nationals. Is it safe to assume that no ABSD involved when it comes to inheritance, and if there's any other procedures or costs required?
I think I have to establish some facts for the benefit of the audience first. Okay, so generally speaking, Singapore has no inheritance tax. So that means that you write in your will you want to give to whoever, okay, there is no tax that you need to pay to transfer these properties to these parties. So in this example that was given, okay, I always like to say this that it's only when you die that you get to transfer your properties freely without any stamp duty. Only problem with that is that you're dead Jokes aside, part of it is because the general principle is that death is generally not a voluntary event. You don't choose when you want to die. Okay, so because of that, there is that voluntariness taken away from the equation. Therefore, generally stamp duty is not applicable, versus every other situation. You sell to this person or you give to this person, there is that degree of volition on your part, okay, to want to do this. So that is and that change of beneficial ownership in those circumstances, that's what attracts stamp duty. So in this case, transferring to the two nieces after they have willed the property, it's fine. It incurs no stamp duty in the Singapore context. But then I noticed that you've mentioned that there are Switzerland nationals.
Yeah.
So the caution that I would state is that even though Singapore there is no stamp duty, okay, that might not be the case for Switzerland. There might be taxes involved when they receive gifts, especially large gifts. So that is something that which is out of the scope of what I can explain and talk about as a Singapore-based lawyer, but that is something that they might have to consider, the two Swiss nieces
because in their country they may have certain laws that
correct
require them to pay certain taxes.
Definitely.
Okay. So what if, let's say, because when we ask about Switzerland, the concern is because by norm in property context for Singapore, they do not pay ABSD for their first purchase, for example.
Correct.
So if let's say today we are not talking about Switzerland nationals, we are talking about some other countries who are not in that ABSD exemption. Yeah. So do they have to pay any ABSD when they inherit?
So generally, the stamp duty profile of the beneficiary in most contexts matters. Okay, but in the context of inheritance, it doesn't really matter. Yeah, because that's the one exception whereby you can freely transfer. So it doesn't matter whether they are Swiss and American or whether they are Malaysian or Chinese national. Yeah, they are still generally able to receive this inheritance without stamp duty.
If a foreigner inherits condo, is it okay? No tax. Can a foreigner inherit a landed property?
I think what is very different about Singapore is that we have these different tiers of property type. Okay, and a classic example for the homeowner is your condo and your landed. So with condo, generally anybody can own it. Okay, you can be foreigner, you can be Singaporean, you can be PR. It's all fine. Okay, it's different when we talk about landed property, because landed property are governed, okay, by LDAU, okay, the Land Dealings Authority Unit. So specifically, they expressly prohibit foreigners from owning landed properties. So in the inheritance sort of situation, what will usually happen is that LDAU will usually give them an approval, okay, to own it for a period of time, but with a view to selling it. Yeah. So there is almost no exception whereby they can receive it as a gift, as an inheritance, and then thereafter own it.
We've come to the end of today's session. If you would like to engage Candice for more legal advice on your property matters, please contact him at the number or scan the QR code to reach him.